Welcome to the particulars. We're so glad you're here, and the thing we say every single time because it matters more than anything else we'll say tonight. This is our opinion, our analysis, and it is not legal advice. I run a licensed private investigation firm in Indiana, and I'm also a law student. And Nick has some prior private investigation experience. He brings a few other things to the table as well, but we are not attorneys, and we're not any of y'all's attorneys.
Here's what's on the table tonight. We're going to catch you up all the way on the Lindsay Clancy trial. 2 big days of testimony since we last talked, including a strategy from the prosecution that surprised a lot of people. Then a legal minute that is honestly one of the most remarkable pieces of timing we've ever had on this show. A ruling that came down yesterday from the highest court in Massachusetts that lands directly on the trial we're watching and involves the very same judge.
Then we turn to something a lot of you have been asking us to cover, the flock camera story. So not the version you've seen everywhere, the specific documented cases of what happens when a nationwide surveillance network runs with almost no oversight, including one Texas case that should stop you cold no matter where you land politically.
And real quick, because most of you are watching right now are brand new, the algorithm sent you here, and we're glad it did. Here's the deal. If you like true crime, that's exactly built on the documents, the dockets, the court opinions, the primary resources, not just reaction. That is the entire reason this show exists. We go live Monday, Wednesday, and Friday. So do this now. If you're thinking about it, hit follow, not later, don't do it later, do it now. That's the single thing that decides whether you see us again.
And if you've got even a second, drop us a comment. Tell us where you're watching from. We love it in the chat. We love seeing where all of our people and viewers are coming from. We appreciate and love when you follow us. That means the world to us. And are you following the Clancy trial? It sounds small, but every single comment is what tells the algorithm to show us to more people who think just like you. You commenting is you literally building this room with us.
All right, we're going to do a brief overview of tonight. It is going to be information packed, so stay with us. It's going to get a little long-winded, but that's okay. We are covering the trial watch, which is the Commonwealth versus Clancy, days 8 and 9. We also have the legal minute coming up, and that is the Sanders ruling.
Yes.
Same judge as the Clancy case. We have evidence of the night. That's going to be a great one. We're going to be talking about flock cameras and our red flag, the tool, and who's watching it. With that being said, let's get into the trial watch, our segment 1. A sourcing note before we start, because this is a live trial. Everything we tell you about the Clancy courtroom comes from either the official Plymouth Superior Court docket or an unofficial recording of the trial broadcast that is not a certified transcript. Where the exact words matter, we'll tell you which ones we're leaning on.
So for anyone brand new to the case, Lindsay Clancy is on trial in Plymouth County, Massachusetts for the deaths of her 3 children, Cora, Dawson, and Callan in Duxbury in January of 2023. She has never disputed that she caused their deaths. What her defense disputes is whether she's criminally responsible. That's Massachusetts' version of an insanity defense. And it argues she was in the grip of severe postpartum psychosis and could not appreciate that what she was doing was wrong.
When we left off Wednesday, the Commonwealth, the prosecution, was still putting on its case. Since then, we've had 2 more days, and we're going to walk them in the order they happened. Day 8, Thursday, opened with the hardest testimony of the entire trial.
All right, so on Thursday, The very first witness was the medical examiner, Dr. Kimberly Springer. Now, an important note on what people actually saw. So inside the courtroom, the medical examiner referred to specific autopsy photographs by exhibit number, and the jury viewed them on small screens in the jury box. But those images were kept off the public broadcast. So if you were watching the stream at home, you heard her reference the photo numbers, but you never saw the photos themselves. And neither did we. Lindsay sobbed in the courtroom throughout. We're not going to describe those images, and we'll gently say, if that's a hard thing to sit with, it's okay to step away for a minute. We take no pleasure in any part of this. So after that, the tone shifted quite completely. The rest of day 8 was witness after witness who actually was describing Lindsay as a good mother. Close friends, a coworker, the children's pediatrician, and the one that stops you cold, her former father-in-law, Christopher Clancy, the grandfather of the 3 children who died, called by the prosecution, testifying about the woman on trial for killing them.
And on the stand, he said she was, his words, very mothering, very protective of the babies when they were little, that she was a good mother.
So why would the prosecution call witnesses who make the defendant look like a loving mother? That feels backwards. It's not. It's strategy, we are assuming in this situation. And we are understanding it tells you a little bit about what the Commonwealth is thinking.
So the logic goes like this. The defense's whole case is loving mother destroyed by psychosis, not a monster. The prosecution knows the defense is going to put on good mom witnesses no matter what. So the Commonwealth calls them first. They take the sting out of it. They control how it comes in and they reframe it. Yes, she was a good mother, which is exactly why deliberate, planned actions are so chilling. They're not conceding the point. They're stealing it and turning it around.
But it also cuts both ways. So, and this is the part that matters. On cross-examination, Lindsay's defense attorney, Kevin Reddington, took those same prosecution witnesses and pulled more out of them. Her friend, Amy Bevins, agreed Lindsay was, quote, a good person, a good friend, and a good mom. And then confirmed Lindsay had texted her about a specific medication in late 2022, reported she was having difficulty with her medication, and told her toward the end of January 2023 that she was having, quote, dark thoughts.
So the prosecution's own witness became a defense witness on cross.
Correct.
That's the risk of the strategy. You put a friendly face up to control the story, and the other side gets to cross-examine that same friendly face. Today, day 9, still going on as we speak.
It wrapped up.
It may have wrapped up.
Yeah, we're wrapped up, but
yeah, it wrapped up. We were looking all the way up till 5:30.
I was still looking
at
as of
trial
like
testimony.
8. Well, and because I pulled the docket and I'm doing all of the things.
So day 9's wrapped up. The testimony moved to a psychiatrist who actually treated Lindsay in the week before the children died. This is the heart of the defense's case. One of them, Dr. Goodhart of McLean Hospital, treated her at the beginning of January 2023.
Yes, and here's the honest headline from today because it did not go the way the defense needed. The 2 clinicians who actually treated Lindsay in the weeks before the children died, Dr. Goodhart at McLean and Dr. Tufts, her outpatient psychiatrist, testified that when they saw her, they did not observe signs of psychosis. Goodhart diagnosed her with insomnia after their first meeting and testified Lindsay had no history of psychosis or postpartum psychosis at that point.
And that matters because the defense's whole case is postpartum psychosis. So the prosecution is using the treating doctors to say the professionals in the room with her in real time weren't seeing it. That's a genuinely hard day for the defense, and we're not going to pretend otherwise.
So the defense pulled out the flip side. On the intake forms, Lindsay herself checked no to essentially every suicide and harm risk question. No plan, no thoughts of hurting herself or others, no voices. And the defense's point with that is layered. Either she was being screened by people who missed how sick she was, or her inability to report what was happening to her is itself part of the illness. That's the argument they have to win.
The teachable piece, and it ties straight to our legal minute, a treating psychiatrist diagnosing in the moment is asking a different question than a forensic expert reconstructing her mental state after the fact. I didn't see psychosis in a 20-minute, appointment. It is not the same as she was not psychotic when she killed her children. The defense has retained experts, and the judges is still deciding whether to fully admit or where that fight actually happens. Now let's guardrail that real quick, because one more thing happened today that's all over social media, and we're going to handle it carefully because it is disputed. After Thursday's autopsy testimony, as Lindsay was sobbing and being led out, a voice was picked up on a courtroom microphone. Defense attorney Kevin Reddington told the judge today he believes the prosecution was caught saying his words, quote, "Shut her up."
So here's why we're being careful. This is an allegation by the defense, not an established fact. The Plymouth County District Attorney's Office says they reviewed the video and that what was said was "shut it off," referring to taking the autopsy photos off the screen, and later said it may not have been a prosecutor at all, but a court employee. Multiple reporters in the room say the audio is genuinely hard to make out. So we're telling you it happened, who's claiming what, and that it is unresolved. We are not going to tell you that we know what was said, because we don't.
What's not in dispute, Judge Sullivan addressed the courtroom before lunch and warned that anyone making inappropriate comments would be removed. No warnings, in his words. So the court took it seriously enough to put everyone on notice, whatever the audio actually was.
And I'm going to give you my honest read on this one, which is just my read, not a fact. We're deep into this trial now, so this was day 9. And when I say we are deep into this, Nic can attest, I have spent hours and hours and hours and hours watching this trial, okay? I personally have lost track of the sidebars that have taken place up to this point. Today, Reddington flat out told the judge he didn't want another one. He wanted this said in open court. To me, that looked like an experienced defense attorney who's tired of taking things quietly to the bench and decided he wasn't going to do it. And I'm not going to tell you that what was on the microphone because I don't know, but the frustration in that room was real. And after this many sidebars, I don't think it came from nowhere.
On the procedural side, the housekeeping that tells you where the trial is actually headed, the prosecution is expected to rest its case early next week. Maybe Monday, maybe Tuesday. When they rest, the defense begins to call its own witnesses. And the defense has been fighting on the record this week to get certain witnesses and experts admitted. The judge heard that Thursday, and as of today, is still sitting on it. Take it under advisement in court language means I've heard you, I haven't decided.
The 3 earlier defense motions we've been tracking for you on jury instructions on limiting certain testimony and an emergency motion about the prosecution's opening statement are all still undecided as of the docket we pulled at lunchtime today. A week later, no rulings. We keep watching them and we'll tell you the second they move. I will say that it is becoming increasingly harder and harder to keep up with what is going on, so to speak, with the docket because you're trying to keep up with the trial itself, and then so you're constantly flipping back and forth.
And understand all the while, before we get to ask if anyone has any questions, understand all the while that there are civil lawsuits that are currently going on that encompass this case. So civil lawsuits
to
between
an extent, yes,
Lindsay and
I'll allow it.
And doctors, and also Patrick and medical facilities and doctors. Week 2. So in context, watching the trial through a keyhole. Before we leave the courtroom, we want to do something a little different, because if you've been on TikTok or anywhere else this week, you've seen this trial explode. Clips everywhere, theories everywhere, people convinced something shady is going on. So we want to talk for a minute, not about the case, but about how you're watching it.
Here's the honest truth. Most people are not watching this trial. They're watching clips of this trial, and those are 2 completely different experiences. I've now sat through, like I said, more than we are at, let's see, 9 days of this testimony, hour after hour after hour. And I can tell you what you get in a 90-second clip is not what's happening in that room. And I am not in the room physically as like a juror or a viewer or anything like that. So I'm still getting a different experience. But I can guarantee you from what I am seeing on social as these clips, it is not what is going on in that
think
courtroom.
about what a clip does. It picks the peak, the outburst, the tears, the one dramatic line, and it cuts everything around it. So you see Kevin Reddington's frustration boil over, but you don't see the 2 hours of dry technical back and forth that led there. You get the spike without the buildup, and a spike with no context always looks like something's wrong.
And then there's the two things that you literally cannot hear. Like I said, sidebars. When the lawyers go up to the judge to argue something outside the jury's hearing, it's silent. The audio is cut on purpose. It's almost never the boring procedural truth of what's actually being argued, because what we do, we can't see what's going on. So we start, well, I don't want to say we, but most people start thinking, okay, well, what's going on? What are they possibly saying? And then, a lot of times, some of those key moments is, for instance, when you see Attorney Reddington, it goes right into, his clip being pulled, but you don't get any context before or after. So the audio is cut on purpose. That's all we're going to say. It's not supposed to be thrown out for everyone to speculate on.
Same with objections. A lawyer says objection, and half the time on a live stream, you can't clearly hear whether the judge sustained it, which means agreed, or overruled it, like disagreed. So you don't even know who won that tiny battle. Multiply that across the 9-day trial so far, and you can see how someone watching it in fragments ends up completely lost. And filling the gaps is with the scariest version.
And I will say on that as well, with the objection, sometimes it is hard to hear them. And I will say also that sometimes Judge Sullivan is not doing, the traditional overruled or sustained. He will say, "Oh, go ahead, answer. I'll let that one." So it's sometimes, unless you're really paying attention, you miss it. So if you're confused or you've seen a theory online that feels airtight, this is why. It's not that you're missing some secret. It's that you're watching a 9-day, hour-by-hour proceeding through a keyhole. Our whole job here is to open the door a little bit wider. That's what the next few minutes are.
And before the timeline, let's talk about the reaction itself, because that's a huge part of what's happening this week. If you're on TikTok or in the comment sections, you've seen it. The clips of Reddington getting louder in the courtroom, clips of zeroing in on the prosecutor's questions, people stitching together their own theories in real time. There's a whole second trial happening online on top of the real one.
And it's genuinely split. So there are videos and threads squarely in Lindsay's corner, and people who see a mother who was clearly struggling and kept asking for help. And then there are videos also and threads squarely in Patrick's corner, and for the victims who never lost sight that the 3 babies died. Both of those reactions are out there in full force, and both come from real people watching the same footage and feeling very different things.
A lot of the loudest reactions right now is about the medical testimony. People online questioning the questions, frustrated by how the mental health side is being handled, arguing about what good care should have looked like. We want to be careful here. We're telling you that reaction exists and it's intense. We're not going to sit up here and grade the doctors or tell you the care was good or bad. There are separate civil lawsuits, like I said before, that exist precisely to answer that question. And that's where it belongs, not on our whiteboard.
No, and with that, here's the thing about all of it. So the pro Lindsay clips, the pro Patrick clips, the doctor debates, every one of those reactions is coming through the same keyhole we just described earlier. So somebody watched a slice, a bit of a reel, and they felt something. It evoked some kind of emotion, and they posted it, which is literally the whole thing behind TikTok. So the feeling is legitimate, but the slice is still a slice. And our job isn't to tell you which side to pick. And it's actually to hand you the fuller picture and let you do what this show always asks you to do. Sit with the details yourself. And one line we're holding all night: being for Lindsay does not mean being against those children. And grieving those children does not make you against Lindsay. The internet keeps forcing everyone to pick a team. You don't have to. You can hold both of those. That's not a contradiction. That's the whole tragedy. Okay.
Let's do that with the piece of testimony that's generating the most confusion online. Lindsay's own medical timeline, the night of and days after. We're going to lay it out in the courtroom only from what's being reported by named news outlets covering the trial. Not clips, not from anyone's interpretation, just the sequence.
South Shore Hospital, the night of January 24th, 2023. According to the emergency physician's testimony, as reported by CBS Boston and Court TV, Lindsay arrived with a core body temperature of about 82 degrees, severe hypothermia. After jumping from a second-story window, she had a thoracic spine injury and cuts to her wrist and neck that were described as superficial. The team put her on a warming blanket and, after roughly 4 hours, transferred her to Brigham and Women's in Boston for more advanced care.
Then Brigham, according to the ICU nurse's testimony reported by CNN, the Boston Globe, and Court TV, shortly after Lindsay arrived, she went into cardiac arrest. She coded. The team did CPR and chest compressions, started what was called a massive blood transfusion protocol, placed chest tubes, and there was spinal fluid draining from her nose. Her spinal cord was severed. She is paralyzed. That's the medical picture in sequence from the witness who was there.
Yeah, and here's why we walked you through it that way. When you see that as 3 disconnected clips, she was warm, she coded, there were transfusions, it can feel like something doesn't add up. But laid end to end, it's a catastrophically injured person, a severe spinal cord, spinal fractures, severe hypothermia, self-inflicted wounds. A body in that condition destabilizing is not a mystery. The gap people are feeling is a gap in the clips, not necessarily a gap in the care. And we'll say this clearly, what we're not doing. We are not the doctors. We're not in that room. We did not treat her. We did not even sit in court today or any of the previous days of testimony. We're not going to make any claim about whether her treatment was right or wrong. That's not our lane. It's not the trial's central question. We're doing one thing, putting the sequence back together so it stops looking like a puzzle it isn't.
And that's the whole point of tonight's detour. Before you accept any theory about this case, ours, a clip, anyone's, ask where it's coming from. A full day in that courtroom or 15-second slice someone chose for you today. We are currently going to move on to segment 2, our legal minute, the Sanders ruling.
Same judge, one day earlier. So this is the part of the show where we're going to slow down and we're actually going to teach the law, because this is why we do this. And tonight the timing is extraordinary. So yesterday, one day before tonight, while the Clancy trial is underway, the highest court in Massachusetts handed down a decision that lands directly on the exact question at the center of the case we've been watching.
The case is Commonwealth versus LaTarsha Sanders. Different defendant, similar tragedy. Sanders was convicted in 2022 of murdering her 2 young sons in Brockton in 2018. Like Clancy, her defense was that she lacked criminal responsibility, that she was in a psychotic break. The jury rejected it, convicted her, and she received 2 mandatory life sentences.
So here's the detail that made us stop cold when we read this decision. The judge who presided over the Sanders trial, the judge whose rulings the Supreme Judicial Court just reviewed, is Judge William Sullivan, the same judge presiding over the Lindsay Clancy trial right now.
So let's be careful and precise, because this is exactly the kind of thing that gets twisted online. We are not saying Judge Sullivan is biased by any means. We are not predicting anything gets reversed in Clancy. What we're telling you is a fact. The state's highest court just reviewed how the same judge handled psychiatric evidence in a very similar case.
Here's what the court actually held, and I'm reading directly from the decision itself, the Supreme Judicial Court's own words. Okay, the court held that, quote, the exclusion of the defendant's relevant medical records relating to the diagnoses of treatment of mental illnesses constituted prejudicial error, and as a result, the defendant is entitled to a new trial, end quote.
Plain English, because it's a whole, it's
It's a really big ruling, okay? But
at the Sanders trial, the judge did not let the jury see thousands of pages of her psychiatric records. The same judge that is handling the Clancy case. Records created after her arrest, where doctors documented hallucinations, paranoia, a history of hearing voices. She had a defense expert, but the expert couldn't lay all the underlying medical detail in front of a jury.
And the Supreme Judicial Court said that was prejudicial error. In their words, it, quote, impermissibly stripped the sole defense of the medical foundation that supported it, end quote. Sit with that. If your entire defense is, I was mentally ill, and the judge won't let the jury see the medical records proving the mental illness, you've been handed a defense with its foundation kicked out from under it. And I will also say, again, that these are two separate cases.
Yes.
And it is two separate times in the, I mean, one, 2018, and the other one is going on right now. So we are seeing in the Clancy case, we are seeing all of the testimony that is being used. And I will say that, for example, when
he got admonished and he changed how he did his job.
I'm not even going to say that, because that's not, I mean, that's what you believe. I'm not going to say that. But what I'm going to say in this situation, with this particular case, they are using, because it's just a different case. It is the same judge, but I think that you have to be careful comparing them, because the cases are different in a way. I think they're parallel, but they're not the same.
So now the legal standard. The teachable piece you can carry to any case like this. When a defendant properly objects at trial and preserves that issue, an appeals court doesn't ask if this or was this a perfect trial. It asks whether there's a, quote, reasonable possibility that an error might have contributed to the jury's verdict. That's a low bar on purpose. The government doesn't have to prove the error changed the outcome. The mere reasonable possibility that it did is enough to undo a conviction. Even a double murder conviction, even to life sentences.
So with this in particular, why does this matter for the trial we're watching today, as you know it is unfolding right now? The central fight is the criminal responsibility case is exactly this. How much of the defendant's psychiatric history does the jury get to hear? That is the ground Clancy is being fought on right now. The treating psychiatrist testifying today, the defense fighting this week to get its experts in, and the judge making those calls was just told unanimously by the highest court in the state precisely where the line is.
If anything, and this is our analysis, our read, not a prediction, a judge whose ruling on this exact question just got vacated, sent back for a new trial, is going to be extremely careful about it the second time around. The Sanders decision doesn't hurt Clancy's defense. It arguably hands them a roadmap.
And that's the takeaway, because how the law actually works, appeals courts don't just decide one case. They set the standard every trial court underneath them has to follow. So a ruling in a Brockton case from 2018 just changed the calculus in a Duxbury case being tried today. That's precedent. That's the machinery, and you're watching it move in real time.
And something we didn't mention in that, it happens all the time where a defense counsel will present something that they want in court to be seen, heard, whatever it may be. And it will get objected to or overruled or suppressed.
Yes, there you go.
When that happens, that is documented in the trial. Now, on appeals process, they go back, your defense goes back and looks at every one of those times that something that you wanted a jury to hear or not hear, it goes against you.
They're creating a running record.
Yes.
So, well, literally a running record.
And if the running record outweighs what would be reasonable to think would change a jury's mind, the Supreme Court will send it back.
Well, the whole point is because if you get to the end of the trial and you have a question like this, where if they would have had access, so we're talking about the 2018 case, if the jury would have seen these documents, would it have changed their opinion on the case?
Right.
Now, what happens a lot of times is things are, they're not, the word just went from my brain. Things are not allowed in trial a lot of times because it would prejudice the other side, one or the other. So they try, it's supposed to be fair and just. However, when you start suppressing things from coming in, we get to the end and we question, if they would have seen this, would it actually have changed the outcome of the trial? So that was the whole point of that legal minute.
Yep.
In a roundabout long way.
And no,
So,
it's crazy that it happened
while this was going on.
Yeah,
That's
'cause
what
it's-
I'm saying.
It's not the same case by any means.
There's just a lot of similarities.
We're about to shift gears from the courtroom to something completely different. So this is the perfect second to do that. And it helps keep the show alive. Because sometimes the legal jargon, people
It gets a lot.
They don't really care
And
about
again,
that
we're
much.
not attorneys. We're not giving you legal advice. We're telling you, as people who have looked at documents and things, this is how we can interpret them. And if you're still with us this far, you're our kind of people. So hello, welcome. You didn't come for a hot take. You came for the actual details. So here's my ask. And I'm going to be honest with you. We're trying to grow this thing big, and we really want people to see this information. The way that happens, it's not complicated. It's simply you. So if something tonight taught you something or made you see a case differently, share this, please. Send it to one person who would get it, who you think needs to see it. One share does more for us than almost anything else.
Yeah, and if you haven't followed yet, this is the moment. We're live Monday, Wednesday, Friday at 9 Eastern. That's the best place to catch us before you can be a part of the conversation. So you can be a part of the conversation in real time. Can't make the live, a full replay goes on YouTube after. And this is new. We're now putting our past episodes out as podcasts. So you can find them, find the particulars on Spotify, Apple Podcasts, like we said before. We're not putting every episode we have so far out immediately. It's going to trickle in.
Slow roll.
It's going to be a slow roll.
You have to search for the Casewalker Chronicles.
Yes, search for the Casewalker Chronicles. That is the actual brand, the name. The particulars is a podcast now within that. It's our lives. So
we just love creating new things to do.
So live, replay, or podcast, there is no reason left for you not to keep up with us.
Yeah, and we're on everything. We are on YouTube, TikTok, Instagram,
but
Facebook.
The follow is what makes it happen. Please, please, please do it now. And I just see, look at that. We've got Coconut Tree Brat. We've got Miss Sky Nova. Thank you all
we probably
so
missed
much.
a ton of the follows.
We've got Glinda the Good Witch.
It's an awesome name.
Stevie's up there. He followed a while back. Karen Lyons. I know we missed some, but we're trying to keep.
Thank you so much for all of the follows. We appreciate
Eli,
it.
thank you so much.
And for anybody who wants to go one step further and actually help fund the work, the court records, the document pulls, all of it, our coffee, you'll hear me say it both ways because I don't really know. It's in the description, the Research and Records Fund. So no pressure ever. The follow and the share help us just as much. And I will say we do have stickers and we have a t-shirt. One of our key phrases is hopefully things are clear as mud. Yeah. And so we do have a t-shirt. Yeah. That's on Sticker Mule. All of our links, you can find that.
So thank you for sticking with us for our little plug there for our merch and stuff. But we
are now ready to go to the evidence of the night. I feel like there needs to be some like saxophone or something that plays some kind of.
This is gonna be a wild one.
Yeah, hold on to your hat because we're gonna keep digging here. So
you've probably seen flock cameras and not known it. They're those small automated license plate readers mounted on poles alongside the roads. They photograph every passing car, read the plate, log the make, model, color, and time, and feed it all into a giant searchable database that police departments across the country can tap into. The company, Flock Safety, runs more than 120,000 of them, scanning something like 20 billion plates a month.
Most of the flock stories you've seen are about a rogue officer, one bad actor abusing the system. We're going to get to that, and it's real. But we want to start somewhere more uncomfortable because it's the harder question. What happens when the system is used exactly as designed by people acting in what they believe is good faith, and it's still staggering?
Last year, in 2025, in Johnson County, Texas, investigators were looking for a woman they believed had self-managed an abortion. To find her, according to records later reported by 404 Media and the Dallas news outlets, detectives ran a search across more than 83,000 flock cameras, a nationwide dragnet to locate one woman's car.
And here's the detail that we cannot stop thinking about. When an officer runs a flock search, they type in a reason. The reason logged in the system for this nationwide 83,000 camera search was, quote, had an abortion, search for female.
Now, in fairness, and we always do this, the sheriff at the time, Adam King, later told the Dallas Morning News that investigators believed the woman could be in medical danger and wanted to make sure she didn't need care. And a medical examiner later determined that what was initially believed to be a fetus was actually a blood clot. So the framing from law enforcement was a welfare concern.
But sit with the scale of it, regardless of the intent. 83,000 cameras nationwide to find one woman over a reproductive health matter, logged in the system in those exact words. That's not a rogue officer breaking the rules. That's the tool working as designed. And that's the part that should make everyone, and I mean literally everyone, across the entire political spectrum deeply uncomfortable. Because the question isn't just what if someone abuses this, it's what does the normal, authorized good faith use of this actually look like?
One more piece of context, and we state it carefully. That sheriff's been indicted on unrelated charges. Perjury and workplace sexual harassment because he's a piece of work. That's a separate matter from...
And that's Nick's opinion.
We say this is our opinion.
I am just saying, I'm making sure people know it's our, that part is your opinion.
That's a separate matter from the camera search, and he's entitled to the presumption of innocence on it. We mention it only because it's part of the public record on the official who defended this search.
So, at this time...
Are we going to talk more about flock? Because I legitimately wanted to push through a lot of the other stuff because I thought that was going to be a lot more.
Are you excited?
Is it in the red flag?
First of all, I'm gonna let you quit rushing me along.
This is gonna be so good.
Yeah, so just slow your roll, okay?
I thought you put it in the red flag.
So
I'm so excited.
The thesis that makes this cross-partisan and on-brand, the danger is its abuse, right? It's that it was intended. So it's not necessarily, it was authorized. So in that case, it was the authorized. However, it was such a huge thing. It's what makes it seem questionable.
So bridging the gap between evidence of the night and our red flag. A Washington Post investigation this month found at least 50 law enforcement officers across the country who've been charged with or accused of misusing automated license plate systems. Flock's network was involved in 46 of those, and in 26 of them, more than half, officers used it to spy on wives, girlfriends, exes, an ex's new partner, or a woman they just wanted to meet.
And I want to tell you about all of them, because a member on a page doesn't land the way a name does. So her name was Marcy Bakley, 50 years old, a single mom in Georgia. She dated a man named Michael Steffman, and Michael Steffman was the police chief of a nearby town. And I think it's Brazelton, Georgia, is how you pronounce that.
After they broke up, she kept noticing he somehow knew where she'd been. And according to the audit logs, the records of who searched what, Steffman ran her license plate and her teenage daughters roughly 600 times over about a year. 600 searches. On one single day, 21 searches using the police surveillance network to track a woman who had left him.
And when she confronted him about how he kept knowing where she was, he texted her. And I want to read this exactly, okay? So, because it's chilling and it's just the casualness of it. So he wrote, quote, "Don't worry, I'm not tracking you or some weird stalker stuff," with a laughing emoji, end quote. A police chief joking that he's not a stalker while running her plate 600 times.
She tried to get a restraining order. It was denied. The judge said she couldn't prove ongoing real-time abuse. Think about the trap in that. The abuse was the surveillance, and the surveillance was invisible to her. She couldn't prove it because she couldn't use it.
She couldn't see it.
She couldn't.
Yeah,
she couldn't
doesn't
use
have
the
access
flaw.
to it, right?
Steffman was eventually arrested by the Georgia Bureau of Investigations and charged with stalking, harassing, and misuse of license plate system.
Her question is the whole red flag tonight. She said, "Who do you turn the chief of police into when the person abusing the surveillance system is the system? Where do you even go?"
Now, the company's answer, Flock's CEO, Garrett Langley, who said, quote, "We're not going to change humans, and humans make bad decisions. What we can do is make sure they know if you use this tool, you will be held accountable." And that's true as far as it goes, but here's the accountability gap. And this is the legal heart of it. In most places, an officer doesn't need a warrant to run one of these searches. They don't need probable cause. They just type in a plate and a reason, any reason, and go. And whether anyone ever audits that search depends entirely on whether the individual department bothered to turn on the tools that would catch it.
So there's no federal law governing this. It's a patchwork. So something like 18,000 separate law enforcement agencies, each writing its own rules or not writing any. So the thing standing between you and a Michael Steffman is not the Constitution, and it's not a federal statute. It's whether some department somewhere decided on its own to watch its own people. Here's the tool that actually exposed all of this, and you can use it tonight. There's a website called Have I Been Flocked? It takes the audit logs that some departments are forced to release through public records requests, and it lets you search your own license plate to see if it's been run through the system. It's how the 600 searches on Marcy Bakley's came to light in the first place.
We'll be honest about what it is. It's run by a group that opposes this kind of surveillance. And the data is incomplete and delayed. It's not real time. And a search showing up doesn't mean you were investigated or stopped. They say all of that themselves, plainly, which is actually why we trust it. If you want to see whether your plate has been searched, that's where you'd look. We'll put it in the description.
Because we always show you both sides of a thing, this same network genuinely saves people. So just last month in Greenville County, South Carolina, a mother and her young son were being driven across state lines in a truck by an enraged boyfriend who'd assaulted her. She called 911 from inside that truck, and deputies used the Flock network to find the vehicle, coordinate across 3 states, and stop it outside Bristol, Tennessee. The mother and son were recovered. A man named Alex Burton was arrested and charged with kidnapping.
So look at these two cases side by side, because this is the whole thing. Same tool, same domestic violence context. In one, it let a police chief hunt a woman 600 times. In the other, it rescued a woman and her child from a moving truck. What's the difference between those two outcomes? It isn't the technology. It's whether there was oversight, a warrant, a rule, someone watching the watcher. That's the entire argument. Not cameras are bad, not cameras are good. It's a tool this powerful with this little accountability will do both. And right now, Which one you get is basically luck.
This debate, by the way, is not breaking down the way you'd expect. In Texas, the pushback against these cameras has united Democrats, Republicans, socialists, and libertarians. One Republican congressman compared vandalizing the cameras to the Boston Tea Party. When the left and the right agree that something's gone too far, that's usually worth paying attention to.
And this moved beyond rhetoric this week. Kentucky Congressman Thomas Massey says he's preparing to introduce legislation that would use federal funding as leverage against state and local governments using systems like Flock.
So as of tonight, no bill number or formal text has been filed. This is a stated intent, not an active bill. We'll flag the moment it changes. And notice what Congress is actually arguing about here. It's not whether these cameras ever solve crimes. They clearly do. We just showed you a case where they helped rescue a mother and her child. The question is whether a surveillance network this powerful should exist without enforceable guardrails.
Flock says cutting federal funding would have real public safety consequences and argues Congress should regulate the technology instead. Yeah, have the government regulate it. Strong oversight, accountability, and responsible use rules rather than effectively forcing departments to abandon it. Or we could just have police do real work.
That's what makes this fascinating. Those are basically the two choices we've spent this entire segment laying out. Restrict the technology itself, or keep it, regulate the hell out of it, and who can search it, why they can search it, and who audits them. The citizens are very upset about it. And like I said, I literally in this episode, we talked about two different situations. One where it was used for bad, one where it was used for good. What I'm presenting to you, the viewer, is that you can have both things. They both exist.
Mm-hmm.
What the underlying thing is, to me, my perspective on it, I think there could be huge in terms of benefiting, like
absolutely.
For missing people,
yes.
Things like that. However,
how about we have an organization that is designed to do those things, use it?
Well, the problem is people.
But we think
people are the problem.
We think law enforcement is designed to help, serve, and protect. But
well,
it's being used. It's being used nefariously, plain and simple.
We have. It's the same with everything. We have good people, bad people, good doctors, bad doctors, good police, bad police.
Awful.
It's everything. There's a good and a bad, and the problem is we don't have enough of the good people continuing to care.
Yes.
Don't cut me off like you always do.
I know.
What I'm trying to say most of the time is too many people, we talked about this Wednesday, too many people in our society now, not my problem, not my business, doesn't pertain to me, I'm moving on, not my business. And I don't mean go out and like be like horrible. Like, I'm not saying that. What I'm trying to get across is that there are ways, for example, I do think that Flock could be very beneficial, but there needs to be parameters around it.
Accountability.
Yeah, and accountability,
but
100%.
We don't hold our law enforcement officers accountable.
Well, because who enforces...
The blue wall of silence.
Who enforces the enforcers? That's the whole thing.
Yeah. We're supposed to.
But people...
We're supposed to be the audit for them. We are the one that pay taxes that allow them to have positions to protect us from common day criminals. But what happens is when they abuse their power and become the criminal themselves.
Most of the time when that happens, it takes years and years and years and years and years before finally something happens. We talked about that.
Yep.
Again, you can catch all of our replay episodes on YouTube where we have talked about Flock cameras before. I think it was episode 1 where we talked about Flock.
If you aren't able to tell, this is a hot topic for us.
Yep.
Anything to do with the misuse or mishandling of tools that law enforcement does is a problem.
I'm not going to just say law enforcement. I think, because we see that everywhere.
Authoritative figures.
Yeah, like court systems.
Yeah. Government.
Yeah, well, we see that in medical systems.
Mm-hmm.
We see it in towns. So it's not just simply law enforcement. And I want to state that because I do genuinely think there are some officers that are genuinely good people.
Oh, they're fantastic people.
They have the best poof.
They want to do their job because they want to help people.
That was what I was, yes. Like
they
are
actually
legitimately
they
trying
feel
to
like
do,
they have purpose in their job. And then you have others that just, it's a paycheck to them, and they're going to do whatever they can get away with and not get fired.
And I have said, which I will continue to stand, there are certain professions where you do not get the luxury of just existing.
The ones that don't speak up are just as bad.
So, for instance, if you are a doctor, you cannot be a doctor and decide, I'm just going to go through the motions today. That doesn't work for you.
Right.
You know, when we, like, in my personal opinion, social workers, that's one of those professions. You can't go to work and think, I'm just going to go through the motions today.
Yeah, that could be the difference between a child living and a child dying.
And there are a lot of those nurses. I mean, they're all. Don't come at me. There's a lot of professions like that. I'm just my brain. It's like 10 o'clock at night. But you can't have that. I'm just going to work. Yeah. I'm just going through the motions attitude. And I think law enforcement is one of those jobs. It is
one of those professions. Yes.
When you are potentially responsible for the life or death of another individual.
Yeah. We hold you to a higher standard.
That's called being accountable.
If you don't want to be held to that higher standard,
don't apply. Occupation. Find somewhere else to work. There are plenty of places that need people to work there. This will be our show for tonight. The Clancy trial is rolling into its defense case, a Supreme Judicial Court ruling that just reset the ground under it, and a surveillance network that's rescuing people and hurting them with the same equipment. Headlines end, the details begin. That's why we're here.
If you got something out of tonight, here's the last thing we'll ask, and it's the most important. Follow us right now before you close the app. We're live Monday, Wednesday, Friday at 9 Eastern. The replay is on YouTube after, and you can now find us on Spotify, Apple Podcasts, The Particulars. Look up the Casewalker Chronicles, the podcast, The Particulars. Pick whatever fits your life, but follow so you find us on the next one.
And with that, we will bid you adieu, and we will see you Monday night back here for our next episode of the Casewalker Chronicles, The Particulars.
This has been our opinion,
our analysis,
not legal advice.
See you guys. Have a good
weekend.
night. Have a happy weekend.